Good evening, I'm Pinky Webb. Tonight we ask the questions, we tackle the issues, we clarify matters, and we get on point. Government prosecutors are asking a Muntinlupa court to reverse the acquittal of ML Party List Representative Leila de Lima in one of her drug-related cases. They argue the recantation of former Bureau of Corrections Chief Rafael Ragos was not enough to invalidate his original testimony. Let's get on point with de Lima's lawyer, Attorney Dino de Leon, who joins us on the line. Attorney Dino, welcome to the show. Good evening. Thank you so much for your time.
Good evening, Pinky, and to all our viewers and listeners.
You know, Attorney, I was able to interview Congresswoman Leila de Lima more or less 2 weeks ago regarding her acquittal twice by Judge Alcantara after the Court of Appeals ordered the voiding of her first acquittal by the judge and remanding it to the judge to rewrite his decision. And I recall asking her then, is this it? Is there anything else pending? And she said, yeah, I hope this is it. And then now, this move by government prosecutors, how do you make of it? What do you feel about it? What is this all about for the camp of Congresswoman Leila de Lima?
Well, if the question is how do we make of it, how do we understand this? We don't understand it at all because all of these persecution steps are nowhere to be found in the law books. It is basic, it is elementary for even a first-year law student knows that an acquittal is not subject to a motion for consideration. That is very that is in fact a prohibited pleading, and in fact that is clear in the rules of criminal procedure. No, so in this country there should be an end to litigation. Imagine there's already an acquittal for this case. They subjected that to a motion for reconsideration, which is not allowed, elevated it further to the Court of Appeals. Court of Appeals remands it back, which is to us a violation of double jeopardy. And now the judge had to promulgate another acquittal, and still it's a subject to motion for reconsideration. It's a never-ending spectacle, and they are using so much resources of the public, so much public funds for political persecution. When is this going to stop? And we were wondering, this administration has set itself apart from the Duterte administration in that it does not weaponize the justice system. It does not abuse court processes. So we are asking the question, is this just a move by the panel of prosecutors? Did they get the imprimatur of the Prosecutor General and the Secretary of Justice in this particular case? And if so, what's up? Is it because Congressman Leila de Lima has been elected as congressman? Are they trying to silence her once again? Is this another type of political persecution? All of those questions are still in our heads right now. But definitely we think this is an abuse of the judicial processes. And we are now contemplating the possibility, and in fact we're in the drafting process of filing the necessary cases against those who signed this motion for reconsideration.
Okay, let me cut you there. There's a lot that you had explained about this. When you said a while ago that this have the imprimatur, because this was done by the prosecutors, asking for a reversal, right? Or is it a reversal or a reconsideration? It's a reversal.
Well, it's a reconsideration of the second acquittal. Can you imagine?
Okay.
It's a second acquittal by the same judge in the same case. That's unheard of. And again, it's subject of a motion for reconsideration.
Okay. Maybe for purposes of understanding this, Attorney, help us out, at least for those watching us. There were 3 cases filed against the former senator back then. All 3 were dismissed. I mean, at some point after the second was dismissed, she was out on bail, hindi ho ba? And then
Yes.
after that, the third was also dismissed. So basically, all 3 were dismissed. But this one particular case, I think this is the second case, is the one being questioned.
Correct.
Ito po yun.
Ito yon kasi ito yung ang nag-rely basically yung judge. Ang sabi kasi dito, sabi ng prosecution, in their case, their star witness is Rafael Ragos. So it's their star witness. They're the ones who said right at the outset of this case that Rafael Ragos is credible because he used to be OIC of the Bureau of Corrections and Assistant Director of the NBI. Ito yung kaso na per their kwento, no, per their story, or at least the story that was forced upon them, according to Ragos, was he just woke up one day in the quarters of the OIC director of the Bureau. There was just a box of money beside him, and there was an anonymous phone call. Bring this money to the Secretary of Justice. And all of a sudden, he did the instruction without any questions, brought the money to Leila de Lima. The story itself is already incredible, and then that was the star witness, and that's their only link. That in fact Leila de Lima got money. And supposedly that money is the proceeds of drug trading inside the Philippines, but there was no such thing. No?
Okay.
So that is the main story here. I just want to say that right now they are saying that Rafael Ragos during that time is credible, but they don't want to trust Rafael Ragos' recantation after being subjected to 3 days of cross-examination. And he said, tinakot ako, pinuwersa ako, no less than Secretary Aguirre was the one who was threatening me under the context of a violent drug war where thousands were being murdered, 66 lawyers were killed, no, and the justice system was being weaponized against the opposition. That is the context of this case.
So yeah, so that is the story of Rafael Ragos, who recanted his testimony.
Yes.
And with regards to the second drug case against the former senator back then, as you mentioned, it relied solely on the testimony of Rafael Ragos, who again recanted and said he was forced by then DOJ Secretary Vitaliano Aguirre. And I remember, attorney, that the judge said that, in my understanding, not as an attorney obviously, that dahil nagrecant po itong si Ragos, there is nothing that will link Leila de Lima to the drug issue.
Correct. Because this is the only drug case na drug trading supposedly pero walang droga, walang trail of money na pumasok kay Leila de Lima. Laway lang ang puhunan, only the testimony of Rafael Ragos who recanted. So ang sabi ng judge, it is very clear. At the very least, there is reasonable doubt here. Because your star witness, the only link supposedly na mayroong pera na hindi nga natin alam kung nanggaling sa drugs, yung testimony ni Rafael Ragos. So alam naman natin in our justice system, di ba? Ang proof na kailangan is proof beyond
reasonable doubt.
Correct. That's why there was an acquittal.
Attorney, so ang sabi niyo po kanina, balikan ko yung sinabi niyo that you wanted to find out, or you were asking, did this have the imprimatur of the Justice Secretary, etc.? What do you think?
Well,
Do you
sa
think that
aking
the
palagay,
prosecutors will independently act on their own and file a motion for reconsideration?
Well, ang balita namin itong kind of prosecutors, all Duterte appointees, all were appointed and in fact promoted during the Duterte administration. Lahat ito ay talagang nakadikit sa mga Duterte. So at least yun yung balita namin. And ang alam namin is this administration is saying that they will never weaponize the justice system.
Okay.
And they will only act based on the rules, rule of law. Malinaw sa rules nabawal ang motion for reconsideration So kami, naniniwala, siguro naman wala yung Cignal ng Department of Justice. Pero kung meron, siguro dapat ang kailangan natin tutulungan yung Department of Justice at Prosecutor General. It will betray the words of this administration na they are not weaponizing the justice system and they believe in the rule of law if it has their imprimatur.
In fact, even Justice Secretary Boying Remulla has had this new directive among the prosecutors na hindi lang probable cause. Gusto niya likely conviction when they actually start cases or when it actually moves to a full-blown trial. But anyway, that's another story. So, what can be done? Kasi sabi mo nga, there's no bawal ang double jeopardy case. Parang ang sinabi mo kanina, parang pangatlo na to if ever. What can you do? What can the side or the camp of Congresswoman Leila de Lima do with regards to this recent action by the prosecutors?
Actually, ang bilang nga namin, Pinky, hindi nga triple jeopardy. Quadruple jeopardy na to. Kasi nung first acquittal, motion for reconsideration nila, first violation yun ng double jeopardy. Nung dinenay yun, inakyat nila sa Court of Appeals. Second, violation of the double jeopardy. Binaba ulit ng Court of Appeals sa RTC. Third violation yun ng double jeopardy. Ngayon, nag-motion for reconsideration sila. Fourth violation of double jeopardy, jeopardy, di ba? You're putting basically the same person under the same the threat of
Crime,
litigation, the
accusation.
same crime, that's everything, no? Under jeopardy. So quadruple jeopardy na nga ito, eh. No? So para sa amin, malpractice na ito, no? Unethical. We call this unethical and violation of our oath as lawyers, and definitely an abuse of our justice system. So right now we are in the process of drafting the necessary complaint and pleadings against those who seem to not want to stop in persecuting Leila de Lima. No? Takot na takot ba sila? Gusto pa rin nila i-silence si Leila de Lima just because she was elected as congresswoman, just because she will continue the fight, just because she is now prosecutor in impeachment trial. No? Pero siguro, kung meron tayong dapat matandaan nung nakaraang 7 taon, sinubukan nilang patahimikin si Leila de Lima, kinulong nila ng napakatagal, no, halos 7 taon. Pero hindi naman siya nagpatinag, no? Hindi siya nagpapigil. Bagkus, lalo pa siyang lumakas at lalo niya ipagpapatuloy yung kanyang laban.
I want to read part of the appeal, sir. I hope you don't mind. The
Yes, sure.
appeal states, in sum, the prosecution humbly prays that the decision dated June 27, 2025 be reconsidered, considering that the subsequent recantation of Ragos was not sufficient, etc., under oath in the presence of a judge and subjected to extensive cross-examinations, as well as corroborated by several witnesses, to set aside a testimony which was solemnly taken before a court of justice in an open and free trial and under conditions precisely sought to discourage the forced all falsehood simply because one of the witnesses who had given testimony later on changed his mind would simply make a mockery of our criminal justice system. What do you say to that? Especially, I guess, sir, importante dito yung last 2 sentences, to set aside a testimony which was solemnly taken before a court of justice in an open and free trial.
Yeah. Well, the mockery here is the fact that they actually tampered with witnesses. And this is not me. This is Rafael Ragos who said, tinakot ako, pinilit ko, sinabi ko sa mga prosecutors, hindi totoo itong sinasabi ko, pero sila mismo yung gumawa ng kwento. So what is the mockery of the justice system when you're using the justice system, tampering with the witnesses, and manufacturing evidence? That is the mockery of our justice system. Now they said na nag-open testimony si Ragos noong mga panahon na nag-testify siya dito, cross-examine siya. Yung cross-examination niya, very clear na ang daming butas ng kanyang kwento. Yung kwento, okay, bureau chief ka, wala question, may nakita kang pera, dadalhin mo sa pinaka-boss mo, Secretary of Justice, who's a known advocate against corruption. Gagawin mo yun because may nag-instruct sa'yo through an anonymous phone call. Yun yung kwento doon at nakalagay yan doon sa doon sa cross-examination. Huwag nilang kalimutan na yung recantation ni Ragos, almost 12 hours, 3 times siyang nilagay sa witness stand at cross-examine nila ng halos 6 or 7 hours.
So he was cross-examined. There was sufficient time.
It's his recantation, 3 times. 3 times. And then, pagkatapos noon, nag-plead ang prosecution na mag-rebuttal witness pa. Prinisintan nila si yung PAO officer supposedly na nag-swear sa kanya doon sa kanyang unang sworn statement, no. Alam mo, hindi pwede yon na mag-offer lang sila bigla ng rebuttal witness, pero pinayagan sila ng korte kasi nag-motion sila. Ang sabi nila sa motion nila is the recantation Ragos was strong and lent parang their case weak. Sila mismo nagsabi yan sa sarili ng lengguwahe, kaya nga sila nag-move. And sinight yan ni Judge Alcantara, sinabi niya, kayo nga mismo nagsabi that the recantation struck a huge blow in your case, no? So, huwag nilang sasabihin na as if in a vacuum, yung kaso lang yung testimony lang na una ni Ragos, ang na-cross-examine.
Okay.
They had all the opportunity to cross-examine Ragos. It is recantation as well.
Attorney, last question. Do you plan, what are the plans? Is there a plan to elevate this to, I don't know, the Supreme Court possibly?
No, I think ang gagawin dito is we believe that the judge will deny this groundless motion for reconsideration. Apart from the fact that it violates our most fundamental law, the Constitution, it violates the rules of criminal procedure. It's just baseless and it does not have basis both in fact and in law. So I think that they will deny it. Again, baka iakit na naman itong panel of prosecutors who's
Sila po.
brazen in their violation of our rules. Iakit na naman siguro na sa Court of Appeals. Fifth job party na yun. Di ba? Wala na bang
Okay.
end sa litigation dito sa ating bansa? Alam mo, Pinky, gusto ko lang sabihin na kahit na ano pang political affiliation nyo, whether you like Leila de Lima or not, whether you are pro-Duterte, pro-Marcos, o kung ano man yung political affiliation, isa lang ang justice system natin and it's all within our interest to make sure that there's an end to litigation in this country. Masyado na matagal itong spectacle na to. Hindi lang ito ang most expensive frame-up. Ito na rin ang pinakamahabang invento na kaso para lang patahimikin ng isang nagsasalita lamang ginagawa.
A quick follow-up on that. With regards to, of course, you can't speak for the judge, obviously, attorney, but in the realm of the legal sphere, is there a way for a judge to actually maybe even question, decide, or elevate this? Kasi considering that basically the judge is being asked now, I don't know, sabi mo nga 4 times, pero lagay na lang natin at least 3 times on the judge's particular decision.
Well, sa amin kasi dahil motion yan, the judge doesn't have any choice but to resolve that motion, whether to grant or deny it. Pero naniniwala kami, napakalinaw ng kaso na ito. So the presiding judge has already numerous times already articulated his reasons why there's reasonable doubt.
Actually, sorry sir, that's my point. That's actually the point I'm trying to make. Ilang beses ho bang dapat sabihin ng judge na acquitted? To the point that, yun po ang tanong ko, to the judge himself, meron ho ba siyang mararamdaman or pwede ho ba siyang mag-motion laban dito sa paulit-ulit na pagtatanong sa kanya hinggil dito sa desisyon niya on Leila de Lima?
I think, parang pang-troll na to, di ba? Sa dun sa judge. So I think the judge can appropriately ask them to show cause why they shouldn't be cited in contempt for gross violation of the justice system and the rules and for abusing, di ba, our court processes. I think that can be a possible remedy. As to whether or not the judge will do that, that's going to be his prerogative. But definitely, we'll have to resolve this incident.
All right. Attorney, I hope you don't mind. I just need to take a very short break. We'll be right back. This is On Point.
Sure.
Welcome back. Still with us, Attorney Dino de Leon, the lawyer of Congresswoman Leila de Lima. I just want to take off, sir, from where we left off. You were saying that a show cause order is possible, that the judge can actually issue a show cause order against the prosecutors?
Well, that is very possible because at least in our opinion, this is a brazen abuse of the justice system and the court processes, di ba? Parang pagtotroll na eh. Ilang beses ba kailangan sabihin ni judge na acquitted nga, no? Parang hindi ba kayo titigil? At para bang walang end sa litigation. So for us, this is a clear violation na, and that can be the prerogative. That can be a remedy by the judge or an exercise of his prerogative.
To your recollection, has a similar incident happened in the past?
There has always been, di ba? There's always there will be instances wherein if there's a gross disrespect of the court processes. Yes, ang daming beses na sinoko sa mga lawyers why they should not be cited in contempt for abuse of court processes. Marami yan sa jurisprudence.
All right. Just briefly, let's move to the impeachment case against former Vice President Sara Duterte. Sir, so just wanted to kind of get your reaction on the Supreme Court resolution asking the House, information regarding this impeachment case against the Vice President, such as when was it filed, what happened to the 3 previous cases, did the House, were they in order, did they not violate basically the Constitution, did they include the impeachment complaint within the 10 session days, etc. Your Congresswoman Leila de Lima was saying this is judicial overreach. I was also able to speak to former Supreme Court Senior Associate Justice Antonio Carpio, and he did echo what Congresswoman Leila de Lima said, that this is a judicial overreach, at least to that point when the Supreme Court had asked, did you read, were you able to peruse through the papers and verify this complaint? What are your thoughts, sir?
Well, ako dadagdagan ko lang rin siguro yun. No? I just like to add to that point na the House is a co-equal branch of the Supreme Court. No? And it's a little bit insulting for, of course, the House to be asked whether you've read something before you signed it. Because that could also be asked by the House. Let's say, for example, when the Supreme Court decides on something, can the House ask them, did you read it, or how was your deliberation? In other words, in constitutional law, there is judicial separation of separation of powers between the three equal branches of government. They are supreme in their own spheres, and per the Constitution, the House has the exclusive prerogative to initiate impeachment. And when they initiate impeachment, that shouldn't be questioned by a co-equal branch. Why? Because the Constitution actually put that exclusive power on the House of Representatives. No? So yun lang yung comment ko. And there has been instances wherein the Supreme Court exercised judicial restraint. I think in this instance should be one of those, because the impeachment process is quasi-political and quasi-judicial. But the political side, which is the initiation, has already been accomplished by the House. That should be respected by the Supreme Court. And it should be the High Court of Impeachment, which should be the Senate, who should try it exclusively. And a co-equal branch, like the judiciary, is alien actually, is not part of the impeachment, except when the president is the one on trial, wherein the Chief Justice will sit as the presiding officer. Other than that, it is my humble submission, as a continuing student of the law, that the Supreme Court should not meddle with the impeachment process.
For your information, former Justice Antonio Carpio actually said the same thing, that tinatanong ba daw yung mga justices kapag nagkaroon sila, when they render a decision, if they actually read the decision. You actually echoed what
I didn't
Justice
know
Carpio.
that.
Yeah.
Justice Carpio. Kasi talaga naman, di ba, parang ang hirap naman yata, tatanungin ka, binasa mo pa bago pinirmahan. Alam naman nating lahat na kahit na ordinaryong tao, hindi mo kailangan maging abogado, na pag pinirmahan mo yan, ibig sabihin, you signify assent and you've read, di ba, what you're signing. That should be the presumption. And I think it's a little bit insulting to say pinirmahan nyo pero tatanungin mo kung binasa. No? I think that is too much for the Supreme Court to ask. At least, but we'll see. No, this is a pending case, so
Okay.
We hope that the Supreme Court will be able to exercise judicial restraint.
Just what do you think is going to happen once Congress begins the 20th Congress come July 28th, the son of the president, and of course, yung talagang first official day nila would be the day after, July 29. Do you think that there will be a trial? Do you think that manunumpa po yung bagong mga senator judges numbering maybe 7? Do you think that magkakaroon po ng motion already to question the jurisdiction of the 20th Congress to hear the impeachment complaint against the Vice President?
Dahil na-constitute na yung impeachment court, they have no other choice but to reconvene it and then definitely mag-swear yung mga bagong members. But, the Duterte bloc there is very keen in stopping impeachment kahit na, ano lang naman yun, trial pa lang naman pinag-usapan, hindi naman conviction. Bakit? Kasi takot na takot sila na mabilad yung ebidensya. The evidence is so strong and they don't want the public to be able to see it. No? So they are inclined to make sure the trial will not proceed at all costs. No, they don't even want the public to see the evidence. No, so our expectation is that they're going to try to stop it, put it to a vote to stop it, and argue that wala ng jurisdiction, tumawid na sa 20th Congress, kahit sila naman may kasalanan kung bakit tumawid sa 20th Congress. Pero I just want to say sa lahat ng pinaghiraman na, ng instances na may impeachment in the United States wherein two Congresses had to try it, it all continued. This is contained in the Jefferson Manual, and the impeachment of several judges there, kasi ini-impeach to yung judges nila, proceed from one Congress to another. Walang instance na hindi nag-proceed.
Alright.
No? So kung saan natin ito pinaghiraman, I think that particular argument is ill-advised, so to speak. No? But yes, they will try to stop it, and hopefully our senators will be guided to at least try to proceed to trial. No? Kasi kung wala naman silang tinatago, walang ebidensya, titignan naman yung ebidensya. In fact, this is an opportunity for Sara Duterte to clear her name.
Attorney Dino de Leon, lawyer of of Congresswoman Leila de Lima, former Senator Leila de Lima. Sir, thank you so much for your time.
Thank you very much, Pinky. It's always a pleasure.
Thank you. That's On Point. Join us again tomorrow, 7:30 p.m. here on BNC, the Billionario News Channel. I'm Pinky Webb. Thank you for watching.